All right, so we'll get the meeting underway. So I'll look for disclosures of pecuniary interest. Seeing none, we'll get the meeting started underway. So just look to committee to see if they'd like anything pulled. Councillor Armstrong.
Number 5, and I'll be brief.
Promise. Councillor Usher, it looks like you're interested.
Yeah, I'd like to pull 2 and trying to remember why I want to pull 9, but I'll pull 9 also.
Any other items? Okay, go ahead, Councillor Cassidy.
So I have a question on 7, but I don't need to pull it. So should we
Ask away.
like put a motion on the floor for the
Sure,
other?
so we'll get a motion up and in the meanwhile, ask your question. You have to do it right now, like right now.
Okay. Did anyone pull number 3, Mr. Chair?
Yes, I believe so. Nope. Would you like that poll? Yes. Okay.
And I'll go ahead with my question on number 7, through you to staff. I just have a question about the milestone about the schools, the school closings. It's, so my question is just that the province has announced that they would retain holdings or properties that are provincially owned, potentially to be used by First Nations or Indigenous or Aboriginal communities to have a community hub, as an example. So I'm just wondering how, if that fits into where we're going, and do we account for that, knowing that this is fairly new, I think, coming from the province?
Through the chair, Mr. Fleming has the lead on this. However, I do a fair bit of work with the schools and surplus properties. So Mr. Fleming is leading the development of this framework. The province is moving very quickly on its community hub strategy, and I think that is an important aspect of what Mr. Fleming will be taking into account in the development of this particular piece. When council first set the strategic direction, it was pretty static at that time. So I'm quite sure that Mr. Fleming will be looking at those very recent announcements on not just for Indigenous community hubs, but also community hubs for communities in general. I'm happy to convey your question to him. So, not seeing any other speakers, so we'll call the question, and we've already polled 2, 3, 5, and 9. So just look for mover and seconder once it's up. Once it's up. Once it's up. Nice shirt, Esquire. And we're calling question. Hold on one sec. Mr. Cotola?
Through the chair, I have a friendly amendment to item number 6, and that is to remove 200 Adelaide Street North from the list of property standards related demolitions. There's been a recent property transaction, and the new property owner is moving rather swiftly to complying with the property standards bylaw, bringing the property into compliance and putting the property on market. We inspected yesterday and today, and it's moving along rather swiftly since this report came out for a possible demolition.
So I'll just look to committee unless there's any objections. The clerks will amend it post this vote. So just looking if there's any concerns. All right, so we'll continue with the vote. Thanks, Mr. Cotola. Mr. Usher.
Closing the vote, the motion carries 5-0.
Item number 2. Councillor Armstrong, I believe. Oh, Councillor Usher, sorry.
Thank you, Mr. Chair. I guess one of the reasons I pulled this is because I need some help and some clarification I do appreciate this delegation. What I don't understand is, after all this, where do we stand? Who has responsibility? Is there still some responsibility with staff? Because we've got the Middlesex London Housing Corporation, we've got the London Development Corporation, and then we've got this portion of staff, and we are delegating, I'm assuming it's only some of that responsibility to the Housing Development Corporation. And I'm at a loss. I try to read this thing and I really can't find out exactly what is being left here. So is there a way you could help me understand this tripartite thing?
Thank you for the question through the chair. I think it's important for us to be able to provide information to you, and I'm happy to do that offline as well, Councillor Usher, to kind of show the scenarios in terms of maybe some pictorial pieces, because it helps a little bit. Suffice it to say, the City of London is the service manager for housing. So we have the ultimate responsibility for the delivery of housing and for homelessness services through Ms. Livingston's area. As it relates to the transfer of funding from the province and the delivery of affordable housing, the support of existing housing, social housing, support to public housing, which in our case is run by London and Middlesex Housing Corporation, and for the development of new housing, which through this delegation and through the development of the Housing Development Corporation, Council has deemed that the HDC would take on the responsibility for development of a new affordable housing. This document, or the information that's included in this report, is to delineate or to define the mechanisms by which we will assign the responsibility for the development of new housing to the Housing Development Corporation. The city and civic administration continues to be responsible as the service manager for housing. So we will still have a housing department, we will still have housing staff that run our Housing Access Centre, that support our social housing providers, that give support to London Middlesex Housing Corporation, which is a standalone organization that runs our public housing, which the city owns on our behalf. And the Housing Development Corporation will take on the lead for developing new housing and will get from us as the service manager the money that's flowed to us in that regard. Through the development of the Housing Development Corporation, you've allowed the development of new and unique strategies that allow us to develop housing in ways that we haven't been able to do as a service manager. Happy to give you more information offline, or even to give you some more information as we did as part of that orientation a couple months ago. I can kind of show you a schematic again if that works for you as well.
Mr. Chair, I would be happy to just sit down. I don't want to take up everybody's time because I think that it's a matter of languages and getting that into my head. So at some point in time, I would like to sit down with staff, and then if I need to, then I'll ask for another report. But I don't want to get that report unnecessarily. What she has just explained to me, what staff has just explained to me, is good enough for right now. So I will call them and make an appointment with them. Thank you.
Thank you. Councillor Cassidy, and it's been moved by Councillor Usher.
Thanks. It's funny because I had written like a little comment on my report. It's really similar to what Councillor Usher just asked, and what I had written was like a chart. I'd written the word chart. So I know that you did a great presentation like not too many meetings ago, but every time something new comes up, it's the same thing. It's like there's so much information, and it's kind of, it feels like that in my brain. So if you could put together a chart for the councillor and you could share it with us, I think that would be great. Thanks.
So seeing no further speakers, we'll move and second the motion, and then we'll call the question. And we're voting.
Closing the vote, the motion carries 5-0.
Item number 3.
Thank you, Mr. Chair. This is a great report. I want to thank staff for that. There's some good news things in here, and then maybe some not so good news things. I'm just wondering, I know we had seemed sort of static when we first were doing the work with the poverty panel, and it had seemed like the economy as a whole was recovering from the recession, but the people that were living in poverty weren't necessarily seeing benefits that the rest of society were seeing. So I'm wondering if overall, if staff could comment on that, are we now seeing movement to the positive overall? Like, I know there are a lot of statistics in here and some things are getting better and some things are staying the same. So I'm just looking for a comment on that.
Through the chair, thank you for your questions. I think it's reasonable to say that our caseload in terms of those individuals and families involved in the Ontario Works program has remained static. So it hasn't increased. So I think that's a good thing. I think of an overall population or percentage of the population, it's actually less as our population grows. We know that not only is the caseload static, but also it's less as a total number of the population. I think what you see in here and what is perhaps not some of the better news is that the people who are on the Ontario Works program are having perhaps a little bit more difficult time finding employment, especially those who are on the program for longer periods of time. So I think, while I haven't done the research, and we haven't done the research about kind of like how many months before people come off, we can get that information, and it's probably reflected in some of the information towards the back. We do have exits to employment, but I think the demographics of those that we support through the program is older, and they've been on the program longer. So their opportunities towards employment sometimes become more complex and are more difficult. I think where we've been able to be successful is supporting those who come on in the program for a quick need or a support, whether it's through employment insurance running out or supports to moving forward. And then through our employment programs and the work with our purchase of service partners, we're able to help to set up employment opportunities as quickly as possible. That work initially gets people in, and I'll say quite frankly, back out again and back into the system. So we have a bit of a dichotomy in terms of the caseload. While it's not growing, we have people who are staying on it longer because of an increasing age piece as well, and perhaps a little bit of the demographics of our community as well.
Thank you. So that sort of feeds into my next question, where we see that the number of children has decreased. Is that part of the demographics in the city as a whole? Okay, she says that. I'm saying a yes. And so there's a couple of places in here where it talks about getting off of social assistance, and there's a percentage that end their social assistance because they're going to employment. What might be some of the other reasons why, if it's not employment?
Through the chair, in some cases, and I guess in more cases, in growing number of cases, we support applicants towards getting assistance from the Ontario Disability Support Program, so through ODSP. So we facilitate that application process with our colleagues at the province. And I can tell you that there is an increased number of individuals who are moving towards ODSP. So their rates of caseload, if you want to say it, do increase. So that would be one way. Back to school, maybe leading the community or transferring to another community is another way by which we would see exits off the program.
Great, thank you. And last final question and or comment. So I had the great privilege to attend a Circles meeting. And I got to see Circles in action, and not just the part where, people share a meal and then everybody shares what's going on in their lives. It was at the end, and there was a young woman, a single mother, who has a job and works very hard and works in the social services industry in a group home. But because of different circumstances, and we know how these things pile on, like one thing leads to another, to another, to another, she found herself at a decision point where she might have to quit her job and go on social assistance. And I know we talked about, during the work of the poverty panel, a lot about the systemic barriers and some of the things that are in place by government services that are supposed to help people out of poverty, and yet tend to kind of keep them in. And so it can't be to society's benefit to have this young, educated, hardworking woman quit her job because it's more financially feasible for her to be on social assistance, to pay for her children's medication and the different things that that come along with social assistance, like childcare subsidies and all of those extra things. So the beauty of Circles worked that night because the Circle came together and they found solutions for this young woman for the moment, because all of this is very often precarious. So I'm just wondering, are these kinds of things, because it was based on her income, like she doesn't qualify for a social assistance top up because of the income that she makes, but yet her income varies because it's not a 9 to 5 job. So she gets different hours every week. So is there something that we can do as the delivery of these services? We get the funding from the province and we're delivering provincial services at the municipal level. Are we restricted by what the province is mandating, by what they're telling us the rules are? Or is there something we can do better in London in these kinds of situations? Sorry, that's a really hard question.
Through the chair, it's a good question, hard as it may be. I think it's fair to say that there are many individuals who have a desire and want to find themselves in situations where they get supports from different programs, whether it's from the Ontario Works program or other organizations and their programs within our community, and want to move towards employability and ultimately employability. Within the Ontario Works program, I think there are 2,500 different rules, by the way, the manner by which we need to deliver the program. And the complex piece of that is that in doing that, we want to be able to be helping applicants, clients as best as we can. And so that's through partnerships with other agencies, that's through education opportunities, that's through referrals, that's through things like transportation. We want to be able to support that. That's through an application to childcare, which is linked to social services, but not necessarily with the OW program specifically. I think things like the exemption, they are allowed to, applicants are allowed to have up to $200 a month in employment income that is taken off, so that we don't even use that towards the determination of what they're eligible for as it comes to Ontario Works. I think that the challenge is we continue to work with the province of Ontario around how the program is delivered, what the regulations are with respect to it. I think work that's being done around the basic income and the work that's being done around that pilot will give us a sense about how sustaining people with benefits helps them continue to be able to maintain themselves in their community with themselves and their families. I think it is a broader provincial issue, and I think as we move forward on looking at modernization and reform in the social assistance system, which the province is rolling out over the next little while, and hopefully we'll be able to come back to council to give you a bit of an update about that over the next number of months. We hope to be able to address some of those issues in terms of the way that we deliver services in the mandate that we have with the province. Suffice it to say, it's still complicated and it's not easy to solve. And so I appreciate the feedback and I guess the involvement and the passion of council in trying to get us to support those things moving forward. You may want to, at some point in time, have some discussions with the provincial government. Again, your call about how you manage that.
Any further speakers? So we'll move in Councillor Elmer.
I want to speak a little bit about the increase in the average time on assistance. And you mentioned that it could potentially caused by some unique sort of demographic things that are happening. But if you look like just back to 2012, like the average time has gone up something on the order of like 50%. And that's very troubling, especially when you pointed out that some of the exits from Ontario Works are to long-term programs like Ontario Disability Support Program. So I'm wondering if there's anything that we're learning from working with participants about how the program needs to be adjusted for some of the demographics that are staying, like the ones who are driving the growth in the average time, because 34 months is a lot more than 20 or 18 or 19.
Through the chair, I think part of the challenge of the demographics of that group is that we have, and you can see it from the information here, less children, more single-led families or single participants. They are aging, and that speaks to our demographic in our community of an aging population. The reality for some of our older participants is the further they get away from employment, the harder it is to get back involved and engaged in employment. Employment is precarious for many people in our community. I think the other complex piece is we have employment opportunities in our community. The skill sets that are needed for those employment opportunities don't necessarily match with the people that are in receipt of social assistance at this point in time. And as we have more complex cases, and I say that with the deepest respect to those who are involved in the Ontario Works program, as we have more complex cases and more challenging, vulnerable people who are involved in Ontario Works, sometimes the ability to be reskilled or to move on towards the employment opportunities that exist in our community becomes more and more difficult. And I think I can tell you that we continue to work with our purchase of service partners in our employment areas to look at opportunities for individuals who've been on Ontario Works longer. We do have successes in that. And you don't see that case by case because it's not reflected here because they're trying to give you kind of more generic information. So it's not to share too much privacy information. But I think it's suffice it to say that the economy is changing. The jobs exist in our community. And we need to continually to work with our partners to say, okay, what are you seeing in our community? What is it that we need? We're going to be doing a review, and we've just recently kind of shored up our employment area with some new managers, and we're looking at working with our purchase service agencies to determine what it is that we can do better in that regard. But some of it has to do with the type of employment that exists in our community and the skill sets and the abilities of those on the program and what they can take on and how long they've been on the program as well is a piece of that as well.
So there's a reference in the report to doing more work in terms of analyzing the participant information, and without getting into all of the detail, but are you looking at sort of cross-tabbing all these things to see if there's particular patterns in very specific groups that are, perhaps on assistance for 50 or 60 months, like really long periods of time?
We are, thank you, through the chair.
Seeing no speakers, we'll call the question. And we're voting.
Closing the vote, the motion carries 5-0.
Item number 5.
Thank you, Mr. Chair. Mr. Chair, this item has to do with adult entertainment license, and there is a staff report, and I support the recommendation. And this particular establishment is located in my ward, Ward 2. I want to bring, first of all, the committee's attention that there was a petition submitted for a little over 200 names from people within our community. I brought with me today another petition in support of canceling or the license for that particular location. The petition I brought with me today has over 200 names, and there's another one online for over 100. So altogether, our community has submitted around 500 names representing 500 roughly homes of individuals in the community who are not in support of seeing any license issued or available at that location for adult entertainment. And in brief, very brief, some of the issues from the past that the community remembers are, finding needles in and around the former establishment's property, a lot of drunkenness when it came to local businesses, people coming in after hours and causing issues. Again, people leaving the establishment in the past, speeding up and down back streets. Another thing, close to when the last establishment closed, there was some type of, I'll call it a bomb that was thrown against the building. And there's been other issues surrounding this. So there's absolutely no interest in my community of Argyle in seeing this establishment reopen or any license issued for adult entertainment at that location. So, and I feel the same way. I don't think We have another establishment licensed within 2 blocks. And there's only, council only, the pass only allowed 4 licenses in our community. So for us to end up having 2 within, in Argyle, in blocks away from each other it's just another issue. So I don't support this at this time. So I think the license we need to review and remove as recommended by staff. I know our staff has a recommendation of timelines to do with this license and potentially another license and some other information. So I'll ask them to give us an overview through you as to how we can deal with this. I would ask that our committee and council deal with this issue as quickly as possible, because it is very upsetting to the community to have to have this this cloud in our community. So we need the thing cleared up as quickly as possible and decisions made. So I hope everyone will keep that in mind. And I know that was over a minute, but thank you.
Mr. Catola?
Through the chair, we can report back on August the 1st to this committee, similar to this report. We just haven't had time to prepare the other report for this committee. And that's with respect to the closed body rub parlor at that location also. And then if committee and council wishes, we could hold a advertised committee meeting for August the 28th and deal with both items at the same time. On that same evening, we will be reporting back on and having another public participation meeting with respect to the whole adult entertainment industry, body rub parlor, strip club issue, because we have been meeting with the industry and receiving comments from them. So we will be bringing back another draft bylaw for consideration prior to the final PPM that we'll be holding on the entire business licensing bylaw in September.
So just as a quick side note, the August 28th meeting, it's as needed, it's a 4 p.m. because there's a planning meeting at that same time, so I'm not sure if that will work, but go ahead, Councilor Armstrong.
Well, even if we have to maybe start one later or whatever, I would like to see it on the 28th if possible. And I understand there's no need for public participation if notices are sent. If staff could clarify that, and then I'd like to do a motion.
Yes, that is correct.
Okay, normally public participation meeting, but these establishments are both closed, have been for years, so there shouldn't be an issue there. And also, the public's pretty well spoken already on this issue by way of the submissions. So I don't really see the need for public participation meeting. I think I can adequately speak for the community, and I think they would like to see this done as quickly as possible. By going the other route, we're gonna drag things out even longer. So I'd like to follow staff's recommendation that they just went through, and if that could be crafted into a motion with the dates, I would like to move that.
So we'll get that motion on the screen and go to Mr. Katolik, and I know we have Councilor Usher.
Through the chair, just for fairness, the applicant should have the ability to address this council as a delegation.
And I'll go to Councilor Usher. I think he had a question.
But first of all, I'm a little confused because I'm hearing about staff recommendation and I don't see one. So I'd like staff to clarify that for me. I do see in here that if we decide to delete one and then we want a public participation meeting, then we could make that recommendation. What I'm a little confused about is, so this report is here in front of us, and I'll call it a report, but there must be a reason that triggered it, and I'm not so sure that I see a reason that triggered it, just because of the fact that it hasn't been operating, which is what I read in here. I need to ask some questions about that. Could you, through you, can I just get from staff why this is here at this point in time?
Through the chair, the committee requested at the last meeting that we report back on this when we were discussing the business licensing draft bylaw. What triggers it is the current business licensing bylaw. And since we wrote this report, we received some further advice from our legal department that a public participation meeting is not technically required, but what is required is a advertised meeting.
Okay, so, it's because of the licensing business that we are going through, those recommendations that you're going through, that this was requested by council to come back with this report, right? So, you're going to... So, some time ago, I think the last meeting we had on this subject a few years ago, there was some suggestions or comments or understanding that I think this is the location was closed for a long time. And the way it was justified to not take the license away, if I remember rightly, was because of there was some business that were taking place at noon hour, but not for the public. Could you enlighten me or remind me about that?
Through the chair, that issue was approximately 6 to 8 years ago, and the location was not this location, but another location on Dundas Street. And at that time, the former licensee provided affidavits that there was private parties at that establishment and that adult entertainment services were being provided for private parties. At that time, and currently, the regulations with respect to a location being dark for 6 months is in the bylaw. Under the new draft bylaw, we are not recommending that because we are just allowing supply and demand and market forces determine which locations are going to be successful, which ones aren't, which ones will close because of supply and demand in the marketplace. It was difficult during the last public meeting to determine unequivocally whether the place was dark for 6 consecutive months because affidavits were provided that patrons were at that location without alcohol watching live entertainment, adult entertainment.
So, Mr. Chair, through you, through the staff, is there a current application to open this location at the moment?
Yes, there is.
Okay, so I'll wait for the motion for what we have coming up here to read it to see how I'll vote on it. Thank you.
So Councillor Armstrong, just for the clerks, could you just read your intent of your motion?
Well, I just want to be clear from what staff said. I believe that they want to bring forward a report on the second license on the 1st of August, then do notification publicly that it will be, both licenses will be discussed on the 28th of August. I think, and perhaps Mr. Kotolik can just make sure I got that straight, that that's the timeline, and that's how things will sort of unfold in sequence.
That's correct if the committee so wishes.
So that's what I wish to move.
So I'm just hearing from the clerks, the August 28th meeting was as needed, and then we hadn't put a notice out to cancel the 28th because it was a meeting at noon. So I just wanted to make you aware of that. So do you want to leave it as at a future date, or I'll just leave it with you?
I'm only going to suggest that I'd like the 28th because my community is, the longer this goes on, the more it's a very big issue. I'm sure that any councillor can appreciate. People don't like having this sort of influx, and so I would like to see the 28th.
Okay, so we'll get the motion up in the meanwhile and look for any other speakers. Councillor Squire.
I'm just trying to understand what we're doing and whether this is going to accomplish that. My understanding is we want to make sure people have fair notice, and but we will have a discussion about not renewing the license or canceling the location or reducing the number that we're allowing in a bylaw, because it's not clear to me right now what we're doing at the beginning of August and the end of August. I understand what the councillor wants to do, but I want to make sure I understand what we're going to be doing on those days.
So through the chair, today's report deals with a closed adult live entertainment parlor. On that same property, there is also a closed body rub parlor, which, should committee wish, we could report back on August the 1st, which the report will be very similar to this, will be factual only, and the recommendation it be that it be received. Same process we went to when we closed Legends on Ann Street, and we did a report on RL's on Dundas Street 6 or 8 years ago. And then on, if the committee so wishes, on the 28th of August, we will have a advertised meeting. It does not have to be a public participation meeting. And at that meeting, we will have 2 draft bylaws removing the body rub parlor from that location and removing the adult live entertainment parlor from that location. Both locations, the body rub and the strip club, have active licenses. I need to caution the committee that if the applicant asks for inspections to be undertaken prior to August the 28th, our duty is to inspect because they have applied for license. And if all the inspections pass, the bylaw as it reads, we shall issue a license. So there is a little bit of risk involved in all this timing. I have to be very upfront with this. It is not like previous cases with Legends on Ann Street, where it was dark, there was no activity, no affidavits that there was live entertainment occurring without alcohol, which is quite rare. There was no objection to that place being shut down for being taken away as a permitted location within the schedule.
All right, so just to follow up then, the bylaw also, as I read it last time, provides there's a maximum number of adult entertainment, what do you call them? Facilities? I don't. Live entertainment parlors and the other. And is this going to have any effect on that? In other words, what I'm thinking is if this one is, the license is canceled, does that create an opening for someone else to open another one so that we get up to the, because I think the committee should know that although we may be canceling this license, we're not getting rid of the possibility then of someone else opening one of these places.
Through the chair, that is correct. You'll in essence remove this location off the schedule, but anybody could come in and apply for a new location, and it'll be the prerogative of council to add a new location if they wish to.
But just one last question then. If they apply, we would have to give it proper consideration, whether we like it or not, because we've said a certain number of those facilities are allowed in the City of London, or am I wrong?
That would be purely a council decision if they wanted to add another location. There have been, it went to court last time where another location was added. We felt it didn't comply with the bylaw regulations. And the city was successful in not adding that as a schedule. But that is a definite possibility. And there has been discussions with the industry of adding new locations outside of residential areas. So that's a very real possibility.
Councillor Van Hulst.
Thank you, Mr. Chair. My question through you to staff. When I read the report, it seems that they're doing renovations anticipating reopening the club. So my first question is, what date would they have to ask for an inspection or get a license by before the 6 months is up and they might be ineligible to proceed with that?
If the applicant called tomorrow saying that renovations are ready and come in and inspect, that our duty, if they all passed, our duty is to issue the license. The 6 months is when we're to report back to council that a location is closed.
Okay, so the 6 months, it just means you reporting, it doesn't mean that they've lost their opportunity to open, okay. Thank you. I guess my next question is if I may. If we decide to close this because they haven't asked for a license or finished, and then it was said somebody else could apply for another location, could this location be that other location then?
Through the chair, that would be a decision of council. In my years here, I don't recall somebody, council taking away a location and somebody applying for the exact same location. I just not aware of that situation.
Councillor Armstrong?
Thank you. And my understanding is there's this process to do with these two licenses, but then when we review the overall licensing, we can reduce the number from 4 to 3, and I don't know how many licenses there are for the other type of establishment. But when we deal with the full bylaw, we can reduce the number at that point. So you're eliminating location, then later on, when we do the whole, we can go from 4 to 3. So the only ones that would be licensed, adult entertainment, would be the 3 existing locations that are currently in operation. Am I correct about that, Mr. Katolik?
Through the chair, that would be a hypothetical question, because if we had 4 licensed today, as we do in our current bylaw, and we carried that forward, then to reduce it, council would have to choose one location to remove off the schedule. And I can tell you that we've had a lot more locations for adult live entertainment, and the ones that have been unsuccessful have closed, and then we've removed them off the schedule. So I would expect a court challenge if council directed that a specific location, which has been active for years, be removed off the schedule.
And I can appreciate that, but there's 4 licenses now. 3 places are in operation. So why could we not reduce down to, if this one was removed, why couldn't we reduce the overall licenses down to the 3 that would be currently operating, if that's hypothetical?
Through the chair, in theory, if council reduced under the current bylaw down to 3, they could carry that forward into the new bylaw, into the draft bylaw.
Councillor Usher?
So I'm just disappointed that we're spending so much time on this. Mr. Katolik, through you, Mr. Chair, if we were to just accept your report, just as it is, where does that leave us with respect to this? You said there's an application in process, or there's an application that has come forward?
Through the chair, there's 2 applications in process on that property, one for a live entertainment, one for a body rub parlor. Both are active.
And this is a location that has not been used for over 6 months. This is what you're saying?
That's correct.
So, Mr. Katolik, what's the process of handling those applications at the moment? Because you have the buildings and they're used for that purpose. Do you have to come back to us to say, can we offer these applications or these licenses?
This is a council decision to remove off of Schedule D and Schedule K from our business licensing bylaw 2 specific locations for a adult live entertainment and body rub parlor. So it's very specific to these 2 locations. But I caution council in the meantime, because we have 2 active licensing applications with renovations underway, that if we had a request to inspect for final approval, then our duty is to inspect, and if the inspections pass, then licenses are issued.
I think you still have the floor, Councillor Usher. Are you okay?
Yeah.
if you'll allow me, I just have a question to the chair. So from what I gather from what Councilor Armstrong's intent is essentially to want to close the location, and it's just a matter of the process of how we do that. So, and you had mentioned that if we engage in this current motion that's in front of us, the location could request inspection, and then you'd be required to issue a license. So is there a different process that, or motion that the councillor could essentially raise to just effectively remove the location effective immediately, or is there a more effective process of doing that, or is this the best way, in your opinion, if that's the intent of the councillor? And I hope I'm speaking correctly.
Through the chair, you may want to get legal advice, but to remove immediately may be deemed bad faith, but you may want to get legal advice on that.
I'd like to move in camera for legal advice on the issue because I'm concerned about the issue now that licenses could be issued if inspections are passed. That would put whoever's there back in, that would put them in business, basically. And that's problematic, and I don't know why we're in that situation. So I would like to get some legal advice on this, because I don't think I should speak publicly or ask questions. So whenever, I'd like to move in camera to deal with this.
So Councillor Armstrong, if you're okay, since we have two scheduled items, would you be okay with at the end of the meeting going in camera, since we had another item that we're supposed to go with in camera at the end?
That would be fine if we can do that.
Perfect. So we'll just have a motion to defer this to later. And we'll look for a mover and a seconder, and we'll get that up on the screen. So sorry, just withdraw from the current motion that's on the floor. They're going to put a new motion. So I'm just going to look to who pulled number 9. Was it just a quick was it a quick comment, or did you want us to go into the PPM more? It's up to you. So the motion's up, and we'll look for a mover and seconder to defer to later in the meeting. And we're voting. Would you like to vote manually?
Motion carried 4-1.
So we'll go to item number 9, Councillor Usher.
I just have a quick question with respect to number 9 on page 84. I think it's the second to last paragraph. I'm trying to understand what we're talking about with respect to the financial impact. It says that the City of London was approved for a project worth $435,000, of which $160,000 was provided by the federal government. And then it goes on to say, construction of the splash pad will be completed within the approved project budget up to a maximum of $133,000, and design fees utilize the remaining $27,000. So when I read this, it doesn't sound as though that 133 plus the 27 is the same $160,000 of the federal government. So is this 133 and this 27,000 a different $660,000 than what the federal government is providing? Can somebody help me understand that? Anybody here to help me through the
Yes, through the chair. To answer that question, the city overall, this is an infrastructure, Canada 150 infrastructure project that was approved. The total project value was $435,000. The government's contribution to that value is $160,000. The first phase of construction proceeded last fall in advance of formal approvals on the project from the government's federal infrastructure grant. So when the grant was approved, $160,000 came to the city from the federal government. The construction of the remaining portion of this project, the spray pad and surrounding concrete, in conjunction with consulting fees, will total $160,000. And there is, and on top of that value, $13,000 remaining from last year's city portion of the overall budget. That portion of the total $435,000 will be spent by the end of this deadline for this infrastructure grant. It is confusing how that was worded. Does that answer your question?
Well, not quite.
Okay.
I understand all that. What I don't understand is, does this project here that we're doing, is that $160,000? The splash pad?
Through the chair, the construction portion of that cost, which is what this report is working towards, is $133,000. We have a separate purchase order, which is already established, that takes into account consulting fees to design that contract. Those two numbers combined total $160,000.
If you could just turn off your microphone.
Now, that's $160,000 that you're talking about is not the $160,000 from the federal government per se. It's part of the $435,000, but not necessarily the exact $160,000 from the feds. I'm getting a little confused because it sounds to me as though we're dealing with two different $160,000, although some may be out of the same. We have a total money of $435,000, of which $160,000 is being offered by the federal government. But we have a project here, that it sounds to me, that is $160,000 out of the $435,000. And it just happened that they're the same. Am I right or wrong?
Through the chair, the $160,000 that we're talking about in this report is a component of the original $435,000 contract.
And that's the clarification I wanted. Because when we put it right beside the $160,000 from the federal government, that's what I found confusing. But it is not, part of it may be out of that 160, but in total it comes out of the 435. And that's what you just said, right?
That is correct.
Thanks for that explanation. Thank you, Mr. Chair. I'll move down.
Councillor Helmer.
I'm okay.
So we have a mover, I believe. Again, moved and seconded. Not seeing any further speakers. We'll call the question. And we're voting.
Closing the vote, the motion carries 5-0.
And we have a scheduled item for 405 regarding the council policy for publicly releasing fire conviction information. Oh, Councillor Usher.
Just a quick favor, Mr. Chair. I don't know if anybody is here for 14. There may or may not be, but we're not going to be dealing with 14. So I wonder if we could just get that out of the way. And just so that in the event that anybody is here for that, they can leave. 14 was dealt with at another committee.
Sure, so I'll look for a motion from Councillor Usher, and I'll see if, and Councillor Armstrong seconded. Look for any speakers. All right, we'll get it up on the screen. I believe Councillor Ridley has a question.
I don't have a question. I actually have a pecuniary interest on this item. I just think that perhaps more explanation is necessary to the public rather than just saying this was dealt with at another committee. It's on this committee's agenda. People may want to know when and where it was dealt with or when it will be dealt with.
I see the Civic Works Chair has his hand up.
Yes, thank you. Because we realized that people who might be interested in this item would be disappointed that it had been dealt with the day before, we referred it to our next Civic Works meeting. And so that's when it'll come forward. So thanks the councillor for that.
Thank you. No, I'm not seeing any further speakers, and it's been moved and seconded, and we're calling a question. And we're voting. And the results.
Closing the vote, the motion carries 5-0.
All right, time for the public participation meeting. Just gonna look to staff if they had a presentation on this one, or are we okay?
Through the chair, we don't have a presentation. We've tried to provide additional material in our report, but we don't have a presentation this evening.
Great, so we'll go to the members of the public. We'll look for a motion to open public participation meeting. Councillor Squires watching me. Moved and seconded, and we're voting.
Closing the vote, the motion carries 5-0.
So we have a submission from Cohen Hiley, and I just want them to know that we're listening. Oh, we like that jingle. Marketing works. And I see after that we have the London Property Management Association. So if you just state your name and we'll get the thing started.
Thank you, Chair, members of the committee. My name is Joe Hoffer, and I'm here to represent the more than 500 members of the London Property Management Association. It's an organization dedicated basically to education of the multi-residential industry, cooperation between landlords and tenants, and best practices in managing multi-res property. I've submitted 2 pieces of correspondence, so I know you can all read. I won't go through that. The main point that I wanted to raise was that the proposed policy, the creation and implementation of the policy, is something that LPMA is opposed to. The main reason that it's opposed to that is that the information is of limited value in conveying whether or not a building is safe. The inferences to be drawn from that information may mislead members of the public. That information would be posted for a minimum of 2 years, which again would not reflect the level of safety in the building. And that information, once posted and distributed electronically, can be used in any number of disputes. We see quite often allegations made in the context of landlord and tenant board proceedings, referencing, you know, they want a rent reduction or a rent abatement because this building is unsafe, when in fact that's not the case. But weight can be put on hearsay evidence in front of those boards and tribunals, and that's deleterious to members of the association. I noted when looking through the staff report, and I would just ask, I didn't see it with the material that I have here, but I did receive it from the city. At, I believe, the bottom of page 2, the staff themselves say information within the inquiry system should not be considered a reliable source of information of current compliance, and goes on to say there should be a disclaimer. Basically saying, I know you're reading this, but you shouldn't listen to any of it. You shouldn't rely on it. And the fine print is the stuff that always gets missed. People read or hear what they want to hear and disregard the rest, in the words of Paul Simon. So that's something that your own staff have stated. And then I went to the Schedule C that was attached to the material I received. This goes back to a 2016 report to the CAPS committee. And many of the things that we noted in our submission are things that were noted in the report that went to CAPS a year ago. And so, again, there's no page numbers on what I have, but there's a heading, web posting of convictions, not a reliable source of information for current compliance. And then there follows a discussion about just how unreliable that information is. Under survey of peer practices, 20 other fire services were contacted in Ontario. None of them engage in this type of practice. Over on the next page, there's a wide range of severity of violations, and we pointed out a lot of these convictions are situations where the tenant committed, in effect, the offense. They disabled the smoke detector because they don't like it going off every time they cook French fries or whatever, and but the landlord gets charged because that's the easy target. And they're the ones who can afford to pay the fines. And the fire service has the option of charging the owner or the tenant. And so there's some discretion going to be required. There's some monitoring. So when staff tell you this isn't going to cost very much, that process, the removal of those items, any disputes about those items being there, that's going to cost a lot of money. In terms of building types, you've just isolated multi-res, but you have a lot of other facilities, such as nursing homes that are owned by the city. You have care homes. There, you would think with the particularly vulnerable populations that if you're going to go ahead with this, that should be included so that people who are thinking of placing family members there have something to look at. And again, these places, just like London Middlesex Housing, these are safe. The problem is that there can be incidents which occur, a landlord gets charged or the agency gets charged, and many of these things are the result of tenant activity. Propped open fire doors, failure to report a door closer that isn't working, and as I said earlier, disabled smoke detectors, the batteries removed or whatever. So I'd ask you to consider that. The 2016 report also is critical of the duration of how long these things are posted and some of the challenges that are posed by that. And then at the end of the report, there's a notwithstanding recommendation or submission to the CAPS committee, and the challenges, that's how they describe it, are what level of noncompliance to be posted, what types of buildings, how long would it be posted, information removed from the site can still be retrieved in the future, and then the concern about city liability and the need for disclaimers that basically say all of this stuff is really meaningless. And so it's really consistent with the submission we gave you, Chair. And I'll refer finally to the bottom of page 2 of our letter, which was July 13th, where we're critical of the nature of this policy. And what we urge is a public policy and a legislative approach where you work in collaboration with LPMA and with the industry rather than create this divisive framework for dealing with fire code offenses. We all see south of the border the effects of this divisive report or approach, and I think this council and this city are above that kind of approach, that we should be promoting collaboration rather than division. And really, at the end of the day, this is nothing more than an effort to publicly shame landlords. It won't do anything other than misinform the public about the status of property, and it really does nothing to promote fire safety in multi-residential buildings. So I will say we did ask for under the Freedom of Information request for violations relative to the city. We were initially told it was going to cost close to $2,000. There were thousands of pages. We couldn't get it back till August, and then someone at City Hall had an epiphany and said, well, we just have to provide city-owned property, which were 5 properties, and they turned it over to us very quickly with no violations. They weren't really apartment buildings at all. So we have submitted a further request for 25 properties that are operated through London Middlesex Housing. And I did indicate we'd like a deferral. If council decides to move forward with this policy, we would like a deferral until the results are in so that you can see for yourself, you know, London Middlesex Housing, they operate safe buildings. And I'm in One London Place. Once every 2 weeks, there's a fire engine down there at Little Simcoe Street because there's a fire in the building. And you know yourselves, fires occur, but those are safe buildings. And yet, if you have to post violations and convictions people will tar London Middlesex housing with the same brush that they would tar private industry, and the inferences that they would draw from that kind of posting are, quite frankly, misleading and incorrect. So thanks very much for allowing us to make this presentation. Unless you have questions, I'm done.
Thank you very much. So I just look for, and that's good for now. Any other speakers on this item? So going once, any items, any person from the public wishing to speak on this? Going twice, and third time, and we're going to look for a motion to close the public participation meeting. So it's on the screen, and we'll look for a mover and seconder, and we're calling the question.
Closing the vote, the motion carries 5-0.
Mr. Vice Chair Councillor Usher, can you take the chair for the duration of this debate? Because I'll be hoping to move the staff recommendation.
I have the chair. Any speakers? Go ahead, Councillor.
Thank you. Sorry, I'm not sure if we wanted to go to staff first, or I'll leave that with you.
Does staff want to make a presentation before or make some comments before we debate this as a committee?
Thank you, but no.
Okay, Councillor.
Thank you, Councillor Usher. So, I really appreciate, the London Property Association and Kona Highly coming in this evening and stating their position. I think I did have some questions for staff that were raised through the comments that were made. I just want to give us an opportunity. Can we speak about I know there was one question about does this promote fire safety? And I think maybe the chief might be able to touch on that, to speak on that. Doing something like this, to me, it seems like, yes, it would. And then kind of if you can elaborate the rationale versus why we didn't include nursing homes in some of those pieces. And as well as there was a question made around London Middlesex housing. For me personally, I think if London Middlesex housing is in violation, well, then post them too. I don't care who owns the building. If you're in violation, you're in violation, in my opinion. So through the presiding chair to staff.
Chief Kubota, do you have a comment to that?
Sorry, just writing down the questions. So with respect to promoting fire safety, I would suggest that inspections don't. There's actually research done by Chief Garris in Surrey using, I forget which university there. Inspections make buildings safer if something occurs. Public education is what makes, if I want to say, not buildings safer, but fires are created because of the acts of people, not because of buildings. So it does make the building safer if a fire breaks out, but it doesn't promote fire safety, if I could kind of define it that way. Regarding nursing homes, this started off with a very wide scope. And if we were to include all of them, I think I looked, there's something like 80,000 buildings. And I don't know if that was the whole thing. We were trying to identify what council wanted. And what it appeared to be is that where we have fires more often, in fact, it would be a single-family home, would be in multi-residential, but also single-family would be where probably 60% of your fires occur. So that's what we tried to narrow the scope so we could at least look at that piece. And with regard to nursing homes, we're actually doing a number of different occupancies required by the province. So the province introduced legislation 2 years ago. So annually, we're required to go through. We're required to go through a very comprehensive list. We have to do evacuation drills. So again, they seem to be a bit of a different, if we're trying to prevent fires, again, I don't want to curse myself, but basically fires occur where people live in residences, not that they can't occur in other occupancies, but we believe that the nursing homes have done very well. And with regard to the London Middlesex housing, they would be included in this realm because we don't differentiate. It could be any company, and London Middlesex housing would be included in this process.
Thank you, and through the chair. So I mean, hearing the comments that that London Middlesex Housing would be included in this, they wouldn't be outside of this process. I think this is the best approach and a positive approach. I know there was a comment made earlier through the chair about this being a public shaming. I don't think that's the intent. I believe the information is already available publicly when someone is found convicted. And just wanted to confirm that and ask through the presiding chair to staff, what's the process to get this kind of information? If there's a conviction, I know you can go to court and actually watch those proceedings, but I just wanted to ask you to, through the chair to staff.
Well, through the chair, I'm not an expert on this end of it, but as I understand, when things go to court, they're actually posted on the docket that day. So if somebody actually wanted to attend, they would get the information. There are cases where the public, or I'll say businesses, actually buy inspection reports from us. So if somebody's actually looking to buy a building, probably do good due diligence is to make sure that it meets the fire code, and so they'll actually purchase a report, and they may use that to say, yes, the building's safe, or may use that a negotiation thing, but at least they be buyer beware, and it's a due diligence thing, so it is available that way.
So through the chair, I guess my last comment is really, I can appreciate, comments from the London Property Association as well as the law firm that was also involved in this discussion. But to me, it sounds like this is the best approach for us to protect the community. I recognize that there was a comment earlier made that no other municipality is doing this, and I think that's because we try to be leaders in some regards, and I think this is how we can definitely step up and lead the charge and do a little bit more to protect the consumer, protect the residents that sometimes are victims. We know in my ward there was a fire that happened on Oxford. There was a fire that happened on Oxford when unfortunately an individual passed away. And we see fires throughout the world that have cost many lives. And I think when people have more information, they're able to make more informed decisions. And when someone who is a family member who's putting someone in a residence can access that information a little bit more easier, a little bit more conveniently, versus having to call the city and pay a fee to get this information, that is public information. I can say, if the city posts it on a city website, I appreciate we have some good traffic on our website, but there's nothing to stop me right now as a member of the public to take all this information, which I do have quite a long list of all these violations, which I was able to get easily, and post it up on my Facebook, for instance, and thousands of people will see that, and it'll be widely shared if I chose to do that, and there's nothing to stop me from doing that, so I don't see the harm in allowing people to have the information to make their own decision. So I'll be moving the staff recommendation, and hopefully my colleagues will be supporting it today.
Councilor Squire.
I just want to make clear, there was talk about, through you, Acting Chair, there was talk about fire inspections and the inspections held, but I thought we were talking about publishing convictions here. In other words, we're not talking about doing inspections, we're talking about if you publish a conviction, will it enhance public safety? And through you, that's the question I want the chief to answer. Do you have any ability to say to us today that if these convictions are published, it will somehow enhance public safety?
Mr. Gorbuda.
Through the chair, yeah, I'm sorry. I can't say it's going to improve public safety. I will say that the building will be, the fact that the building owner takes the action to make the building safer, absolutely. I do think I mentioned a couple times, there was a reference to the Oxford Street fire. And sometimes these convictions can take a year or more. So in the case of the Oxford Street fire, it took us 2.5 years to get a conviction. And that happened, I think, approximately in April. So if I was to now put it on the website that building had a conviction, that building has a completely new owner, it's been all renovated, and it's used for a completely different purpose. And so a parent would go on, because I believe it's for student use, take a look and say it's got a red mark, but it's not, because 2 years, like the fire occurred 2 years ago. One of the inspectors told me he has, I think, 3 cases going to court that he actually filed the inspection filed the part 3 about a year and a half ago. So the thing is when things occur when it comes to conviction, as in going to court. It can happen a year, 2, 3 years later. It's the tickets that would, by paying the ticket, that would be a conviction. That would be more real time.
Go ahead, Councillor.
So you mentioned the Oxford Street fire, and you said two things. You said, first of all, now there's a new owner carrying on the business, and presumably they've never been convicted. But the address would, am I right that through the chair, that the address would still show up as a place that there's been a problem? Am I right? Oops.
Well, that's part of the thing that we put in our original report, is buildings change hands. We don't necessarily know a building changes hands. I know of that one because of the case that the bank asked us within a day or two to remove the order so they could take possession, start doing the renovating. But we could post a building today, a building sold tomorrow. We're not notified of that, and then suddenly it's on the other owner. So there is that problem of trying to always keep up this database.
Go ahead, Councillor.
And my last question, before that tragic fire on Oxford Street, were there prior convictions? Like if you had a search, would that person where that fire happened, were there convictions against the owner of that building showing that he had been a bad landlord or he'd done something that endangered people?
Part of the challenge with that building, it was actually, I think I mentioned, well, I won't mention the individual's name, you see it in the paper. It was actually, the building was owned by another individual. There were inspection orders, but to my recollection, there were no convictions.
Okay.
Yeah, just through you, and that's my statement. I'm going to be voting against it, and quite frankly, the chief just provided the reason that I won't be supporting it. First of all, he said that there's no evidence that publishing these convictions will reduce or improve public safety. He indicated that with the one where the fire happened, the problem is now there's a new owner who may be carrying on a very good job. And secondly, where that tragic fire happened, there were no prior convictions, and a tragic fire happened. I know intuitively people think, well, if we get convictions out there, it's going to show us these are bad buildings and people shouldn't go in them. It's just intuitively, I know that's attractive, but factually it's not correct. I have clients, and I know I'm passionate about this, and here I go. Very good businesses. They had an employee do something really bad and cause an environmental problem. Right away, the ministry Googled their conviction. Googled this conviction all over the province and destroyed their business. So I'm not going to support something like this. I know it sounds great, and we're gonna do a better job on public safety, and people are going to be safe, and it's just not accurate. It's just, and I think the chief's just supported me in terms of evidence on that. So I implore the committee, don't take the easy route out on this one, and don't support this.
Thank you. Councillor Armstrong.
I tend to agree with Councillor Squire. He's made some very good arguments here, so I'm not going to support it either.
Councillor Wrigley, welcome.
Thank you. It feels good to be back to one of my favorite committees. I did have a couple of questions, and one, and I recognize looking through the information being part of the previous cycle when we directed staff to prepare this report. One thing that's come to mind since is the lack of details. So specifically in Appendix B, when I'm looking under conviction and what's going to be posted, it doesn't look like there's going to be any details posted about, was it a missing battery, was it a broken fire door? Can you provide clarity on that? Will details be provided?
Through the chair, it quickly caught my eye. So if I go to page 92 under the what, and it says the general contents of the order. So that would be the general items that we found fire code violations.
Perfect. That's what I was wondering. It wasn't clear to me, so I'm glad that there's going to be context as to what's posted, not just conviction at this address, but rather context. My other question is, these offenses, it's not like criminal court, right? Like for the most part, it's like Provincial Offences Act, you would get a fine and maybe you would just send in your check to pay the fine because you don't want to take a day off work. Is that how these would normally be resolved? If someone got a fine, would they just send in a check and that's in effect pleading guilty and would count as a conviction?
Well, through the chair, it could actually result in jail time. So it could be a serious, like, we've had situations where people actually pled guilty and it's in the tens of thousands of dollars. And so I guess they would send in a check. But again, in the Oxford Street situation, I think there was actually some jail time, and there has been some cases like that. So I think Mr. Card might be able to better answer that. But I'd say a ticket would be, yes, you go in, it'd be like a traffic ticket, and either you plead guilty or not. The Part 3s might be a bit different, but I would defer that.
Okay, I'll provide a bit more clarity about my question because I recognize that there are a continuum of offenses, and there's also a continuum of response, right? I recognize that the initial response is one of education. You know, I've been on fire inspections, as you know, Chief, and it's, you know, you need a battery in here, you need to make sure this is plugged in, and a ticket's not written up, but more of a warning and education piece. So if I was a landlord and I'm renting out a house, and I get my annual fire inspection and the fire inspector comes in and says, you know, you're missing a battery here and this door doesn't self-close. Maybe I've got a warning in the past, but chances are they're probably going to write me a ticket and there's going to be a set fine attached with that, and then I have the option to dispute it and go to court or to pay it, and excluding, of course, serious offenses. Am I close on how that process works?
Well, we've stepped up a lot with the ticket component. But yes, if you were an owner and you were found to be in violation of the fire code, and it was, I'll use a smoke alarm as an example, they could do a Part 3. So if you were an owner and you had 23 missing smoke alarms, that would probably be a Part 3. If it's one smoke alarm, it's probably the ticket. They would write out the ticket, and then as is provided for, I want to say, in the country, you have a right to appeal it, and that would be through the courts.
And are we going to issue anything about the warnings or just convictions?
Through the chair, we're really trying to focus on convictions only. So a ticket that you've paid, by you paying it, you're admitting the fact that you were in violation of the fire code. It wouldn't include an inspection order, because an inspection order would be where we found violations, but we're not assuming we have to take you to court. And then the Part 3 might be where you're, if you want to use it, the repeat offender, or it's just a very, very bad situation. We feel we need to go straight to court. It's only when the judge then finds the defendant guilty that that becomes a conviction. So that would be, sorry, the definition.
And so the last thing I want to ask is, I'm trying to compare this to the health unit and how we inspect restaurants. And so if I understand correctly, like every restaurant in the city is listed on a website, and then the date of inspection is there. And you'll see that, you know, 96% of the restaurants have passed or have a green stamp. But in this case, it's just going to be a list of people who have been convicted, right? We're not going to do, you know, here's a residence that you might be interested in renting, and yes, they've been inspected. Sorry, or is that available?
Through the chair, the difference with the Middlesex London Health Unit, and I did have some opportunity to converse with them, they have enough inspectors that I think they inspect their restaurants at least 3 times a year. And I've gone on their site, and so let's say they go today and they find a conviction and it's got a red, and then the people call back and they go back tomorrow, it turns to green, it's listed there, but it's as close to real time as you can get. We don't have the staff to do that type of frequency. In fact, I just asked my staff to pull out the data. We have 4,000, approximately, well, I'll say over 4,500 buildings, properties with residential units that are rented. And with the introduction of the residential rental unit license, we've now added an additional 2,300 buildings. And now with this new push with this secondary units, everybody knows what they are. I forget the actual title. We have no knowledge of that. So whereas the Middlesex London Health Unit can get in there 3 times a year in that building, we might get in once every 3 years or once for 5 years. And that end lies, the problem lies there, because you could take a look at it and it might be posted, but it's not really indicative of any sort of frequency that we would like to get to. We're having a great deal of difficulty finding inspectors, and we've had attrition, and so we're struggling just to kind of keep up with things.
I think, Mr. Acting Chair, that resolves all my questions. This is a tricky one for me because I'm a big fan of open data, and I know I regularly am researching information in other jurisdictions, and I'm amazed at the amount of information that is available to the public in other jurisdictions. And, looking at things like Florida and Texas and BC, and, if I want to find out someone's criminal history or real estate history, I can find that out. And I've always been impressed by that level of data. But I still see some concerns with this and how the public's going to receive it. And so I'll be interested to continue to hear the committee's debate, and I'll continue considering this before council. But I don't know if what we have before us is the solution yet. And I recognize the work of our staff, and I recognize that you came forward saying, we don't really think you should do this. And we sent you back and said, okay, but do it. And you've brought us back a product. I just don't know if it's the right one yet. So I am interested to hear your continued deliberations on this.
Thank you. Well, we have a motion here, but it's not seconded yet. Councillor Van Holtz.
Thank you very much, Mr. Presiding Chair. And I have a question through you, a couple actually, but the first one is, this is a database I might use to decide if I'm going to rent a property or not, but let's just say I don't use it and I rent a property and then I think, hey, there's no smoke alarm here. What do I do?
Through the chair, what we would encourage you, we have a complaint process in place. And so if any resident living in a rented property feels there's any concern, even just a concern, they will call our fire prevention office. We are required by law to actually respond to complaints. And we have our own internal system that within 2 business days we attend. And we will inspect. If you wish not to be named as well, we make sure that we, not go to the apartment or whatever. We just deal what we have to. And then if we find a violation, then we will take the appropriate action.
And how quickly would I see a smoke alarm on the wall? Probably.
Probably when the inspector shows up, we'll put one up forthwith, but we'll make sure that the property owner compensates us, but we're going to make sure that you're safe unless the owner is there and they put it up right then and there, but we're not going to leave you unprotected.
Okay, thank you. I also just make an observation regarding some of the words that the chief has spoken. He said it would take quite a bit of time to deal with the database, and of course time is money. And he also said that our big opportunity is in public education. So I might think that might be a better way to spend funds in order to keep people safe. I think there's some new opportunities for public education, and that would be something for us to look at as well, or as an alternative to this, if we find out that the data that residents would get isn't really that valuable, especially if someone who does rent a place can get action this quickly and have smoke alarms put in there and violations dealt with so fast. So, thank you, Mr. Chair.
Thank you, Councillor Helmer. I just want to point out that we have a motion that's not been seconded yet.
As much as I'd like to second it, I'm not allowed to. I got a couple of questions for our staff. One is, and this is just really basic, and it may have been mentioned in a previous meeting, but I don't recall. How many violations and charges are being laid, and how many convictions are there under the fire code in a year?
Through the chair, Last year, there was 1,000, almost 1,500 inspection orders. There was, last year, there was 83 Part 1 tickets, and we're already at 73 tickets now. And last year was 9 Part 3s, and that's going to court. And currently, we have 30 pending. Part of the problem with going to court is it could take, I'm told, 20 to 50 hours to develop a brief, and then there's court time. So as much as court might seem to be an option, every time we have one inspector spend that much time, that's that many less buildings that are actually being inspected. So we are very careful in how we take people to court, but we do if we feel it's necessary.
So I heard numbers for inspection orders, tickets of various kinds. Well, what about convictions?
Sorry, I don't have the actual conviction number. I would say that the tickets probably are convictions, but the, and I'm not saying the inspection orders, if people do that, we're not considering that they've done it. But like I said, as I mentioned, some of these 9 from last year relayed charges are not even being heard until this year. So, and the year before was only 3 Part 3 charges. So like I said, we're actually kind of ramping up, but it takes a year or two even to get to court.
Okay, so if we assume that the Part 1 tickets are often just agreed to and aren't disputed, we're talking maybe in the order of 100 potential convictions in a year, you know, 80 or 90 Part 1, and then some number of Part 3, some of which are convictions, some of which are not, like they're found innocent. I think it's helpful to understand like the volume of information we're talking about and how much information we're talking about publishing. For my colleagues to consider, I said this in the last time we discussed it, I think it's more helpful to publish the charges rather than just the convictions, partly because it's more timely. I think we do have to be very clear with people that these are not convictions, but that they're the charges. As long as we're clear about that, I think that's more helpful to consumers. I have a second sort of set of questions, which is related to what's already available. So there's in the report, it mentions that you can get information about convictions from POA for a fee. And I just wonder if you give a sense of what the fee is like. And I realize it's not your area, and if somebody else wants to jump in who covers POA, feel free.
Well, I'll just speak to our own thing. Like you said, if you wanted to come and buy a report on a building, or even a fire for that fact, you can purchase that, and that's going to be somewhere, I think, over $100. Regarding POA, the only thing that I recall in our research is that it actually gets posted on the docket, any of the part, so that'll be a Part 3, and that if you happen to be in court, you can get the information. But I know that we did find it even somewhat difficult to get the Part 1 information even for our own use. And then there's that part of the automation piece. So again, maybe Mr. Card could better speak to POA because I'm not sure on that, but I know it's not as not that easy for us to even get the information.
Perhaps Mr. Card want to jump in on that?
Mr. Card, do you have any, you or your staff? Okay, Ms. Marshall?
Through the acting chair. Just to clarify, I understand that it's the docket that's posted, so those would be the charges that are posted. It's not necessarily, it's not, as I understand it, the convictions that are posted. And I haven't spoken with the Provincial Offences Office in terms of determining how a conviction information is obtained from the office, and I'm wondering if my colleague has information about that.
Through the chair, in my conversations with the POA court, they indicated there was a minimal charge for a search, and they could only search by the docket number. There was no ability to search by an address or a name, and you needed a very good reason to be requesting that information.
Okay, one last question for the chief. These inspection reports that are available for a cost around $100, what do those reports include?
Well, basically, what we're doing is we're providing a letter. So if the case there is no violations, then it'll say that on that date, and again, we have to be very careful. We may have inspected the building 6 months or 3/4 of a year ago. On that date, were no violations. If there were violations outstanding, it would show that. But again, you know, inspections are, I come from the manufacturing world. The quality control inspections is basically at that moment, you pick something up, you measure it, it either meets or it doesn't, and you pass it on. And so, again, the inspection is what we found on that date, but it's not necessarily reflective of what's happening today. So if somebody really wanted to be 100% sure, we should go out that day again and inspect to be 100% confident.
Okay, so just to clarify, this is sort of like these inspections can be commissioned. So say like, I'd like you to go inspect this building and let me know if it's meeting the code, or they ask you for, give me the most recent information you have on this building.
Well, if I take the word commissioned, usually that's like through a real estate sale. So somebody might say, you know, I'm buying this property. The person says, fine. You know, it's like, to me, it's a due diligence thing. We've actually worked with Service London to encourage people to look at that too, because we've had cases where people have gone in, purchased a restaurant or leased it. We go in and find out that there's some pretty serious violations that cost a significant amount of money. So we're trying to help the business community find out information in advance. So that would be something that, it's called a request inspection.
Okay, we have a motion on the floor. We don't have a seconder, so I'm going to pass this back to the chair. We don't have a motion, so to speak. I'd like to make an alternate motion. Yeah, sorry. I'll pass it back to you.
No, it's just probably better if you want to keep the chair. You can keep the chair.
Okay. Well, I want to make an alternate motion, and that is to take no action on this subject.
I'll second that.
So then I'll take.
I pass the chair back to him.
Okay, so go ahead, Councillor Usher. He's taking a motion to take no action.
I'll second it.
Seconded by Councillor Armstrong. Any speakers on this motion? So I'll speak from the chair, if that's okay with the committee. So definitely won't be supporting this, and stay tuned for me to bring it back to council and fight for it, because I'm fighting for residents who should have this information, and have no problem standing my ground on this one. Go ahead, Councillor Squire.
Yeah, if the suggestion is that councillors who don't support this are not concerned about residents or resident safety or anything like that, I'm assuming that's not what was meant. I spend all my time here fighting for my constituents. I do it every day. I did it last night at planning, and I accept that. All my colleagues do that. So I'm just going to assume, Mr. Chair, knowing you well, that that's not what you meant.
Nope, I didn't, and you know me well. Councillor Armstrong?
I think I'll, I just want to say again, sort of along the same lines as the other Councillor Squire, that we all are concerned about public safety in all areas, but that this situation is, you know, developed into a situation which I just can't support. Certainly, if you want to go back and you want to work with staff and coming up with, you know, something that makes, you know, makes more sense to some of us, then maybe we can support it in the future. You know, I've heard from the landlord's representative, and he made some valid points. I think Councillor Squire made some very good points on this issue, and I think when I start hearing words like, you know, charged but not convicted, we're gonna. Well, I don't mind if you want to, you know, post convictions. That's fine, but you know, being charged and us posting it and promoting it, that is an indication of kind of guilt. I mean, I have a problem with that. So in any event, certainly go back and work on it some more, and we'll certainly be willing to look at it again.
Councillor Usher and Councillor Cassidy.
Well, I just want to point out to the council that that's not what this motion is saying. This motion is saying take no action, period, and that means it's dead from my perspective. And, you know, I listened to the conversation, and I do respect what everybody is saying, including Mr. Hoffer and all the others. I look at this from a perspective of fairness, and I'm not going to go through all the things that we talked about, but I really do look at this from a perspective of fairness. And I have a lot of concerns also, because I do have concerns about these things happening, and in some cases, they should really be punished, and they should really be publicized. But I'm not going to be the one to say that which ones should be publicized. I look at the conviction, and if the conviction is because of result from tenant activity, which is not a fault of the building, then I have a hard time saying you should publicize it. And then when I look at the fact that people could purchase the property prior to the conviction and all of that, then that other person is being punished for something that they were not have anything to do with. I really do feel that we have to find another way. The other thing, though, is that I also understand, from if I hear this right, is that it's going to be published anyway. It's not just only in a different venue. So I don't think that we should get involved with this at all. So that's the reason why I brought up the motion and just move it.
Councillor Cassidy.
Thank you, Mr. Chair. I just want to ask through you to staff for some clarification. In the summary, it talks about the 3 resolutions that council directed staff to undertake, A, B, and C. So have they all taken place, A, B, and C?
Through the chair, you're referring to our 2016 report, and yes, we have reported back on those.
Okay, yeah, it just, what it's saying in the summary, that urges the Ministry of Community and Correctional Services, blah, 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 and so those are the ones, yes, okay. So do we need to say take no action? Because this is just, the recommendation here is to receive as information. We're not really directing staff, or is there a direction in here that's inherent with the receipt of the report?
Mr. Chair, one of the reasons I brought it up is not because of the second report. The second report says to receive. Yes, I fully agree. But the new one says be introduced and to adopt. That is on page 86. And that's the reason why I made this note. If you want to say receive and take no action, that's okay with me too.
Sorry, I was looking at the wrong page. Okay, so I just want to comment, because I've been very, very quiet through this whole thing. As far as public shaming, posting information that would publicly shame anybody, if anybody is compromising safety of tenants, they should be publicly shamed, in my view. But I don't believe that what you're trying to achieve, Mr. Chair, I don't believe that you would be successful in that. The long delay between charge and conviction, I don't think anybody's going to be made more safe, and from hearing from the chief and Councillor Squire's questions to the chief, I'm not convinced that this is the solution to what the problem is. I know that there are apartments out there that don't have very diligent landlords that aren't looking after their properties, and they're compromising people's safety. But I don't believe we're going to increase anybody's safety by doing this. There may be a better way to go about this, especially if we're talking about people in vulnerable situations, especially if we're talking about people in group homes or anything like that. And I know that there have been, as a result of that fire, there have been a number of improvements in the community for those kinds of people that are in vulnerable situations. So I just wanted to explain my rationale for not supporting the motion that was put forward.
Any further speakers? And we're voting.
Closing the vote, the motion carries 4-1.
And we have next PPM regarding business license bylaw review, lodging houses, secondhand storages, salvage yards, and I believe Mr. Katolik is ready to go up. And just for the members of the public that are leaving, you're more than welcome to follow this as it'll come to council for final decision then. Thank you. And we'll get a motion to open PPM. It's been moved and seconded. 1, 2, 3. Yep. And we'll call the question.
Closing the vote, the motion carries 3-0.
3-0. Sorry. Mr. Katolik?
Thank you. This is the 6th public participation meeting that we're having with respect to the business licensing bylaw. And today the focus is on lodging houses, secondhand stores, and salvage yards. As the previous meetings we had, we focused very much on streamlining the process, looking at modernization of the regulations. With respect to the lodging house bylaw, currently we have 22 licensed lodging houses. The focus of the bylaw is on health and safety of the residents of the lodging houses, nuisance control, and consumer protection. One of the current regulations that we have in the bylaw is that the licensee must maintain a registry of all the lodgers, including personal information and information on their prior addresses. We have never had any reason to access that information, and in discussions with London Police, neither have they. We have concerns that this may be in contradiction to current privacy legislation, so we are not recommending that we go forward with that type of regulation in the bylaw. We are, however, adding a new regulation with respect to signage. We feel that the lodgers, because a lot of them are short-term lodgers, that they have access to any information that they could quickly get information from the licensee should there be any building or property standard violations occurring. With respect to secondhand stores, I'd like to also mention joining me tonight is Staff Sergeant Harvey, who has worked with us on the bylaw. So should you have any questions with regarding to London Police Services and secondhand stores, he'll be able to answer those. A lot of regulations in this type of business. The first three with respect to serial numbers of products, obtaining goods from youth, and obtaining products from persons under the influence of drugs and alcohol. Those are current regulations, and we are recommending that those regulations stay. We're recommending some new regulations around police record checks of the applicants. We're asking that the licensees verify the identity of those that are that they're acquiring items from. We're not asking that their identification be recorded on any document that would be required, just simply verifying their identity. We are asking, however, that a record of all transactions be recorded, and those transactions be submitted daily to the London Police. With respect to the types of records to be submitted to the London Police, the focus is on items that are usually involved in break and enters and theft. So things like electronics, sporting goods, bicycles, jewelry. With respect to submission of photos to the police, the focus is on high-priced jewelry. In discussions with the industry, we recognize that there are a lot of electronics being acquired at secondhand stores. However, a PS4 made last year is a PS4 made last year. There's no real requirement to take a photograph of that. The focus should rather be on recording the serial number and forwarding that to the police. A new requirement also is to have a holding period of 5 days. So when products are acquired by secondhand stores, that they be held and not put on display for 5 days. So should any of those products be involved in any thefts or break-and-enters, they could be returned to their rightful owner. That bylaw, or that regulation, was borrowed from other bylaws that we reviewed across the province. Recently, we did a blitz of all secondhand stores. We have 83 secondhand stores that are licensed in the city. We only laid one charge of an unlicensed secondhand store. These are some examples of record keeping that is being currently kept. So you can see hand-written records. Although they might appear to be useful, in most cases they are not. Most secondhand stores are in the age of computer and point-of-sale software. A lot of them have off-the-shelf software, products such as PawnMaster. Others just simply use spreadsheets in recording their products that are being acquired. We're recommending that we put together a staff-initiated regulation of the types of items that we want information on. So for example, serial number of electronics is quite important. It's not necessary to take pictures of those electronics. And that information be kept on either an off-the-shelf software or a form of a spreadsheet and be submitted to the police on a daily basis. Lastly, salvage yards. With respect to those, we have 13 licensed salvage yards in the city. Also, they are important in solving the theft of materials, specifically building materials such as copper and aluminum. The one regulation that we're looking at as a staff regulation is one regarding nuisance. Because of the activities in salvage yards, we're recommending that there be fencing regulations put in as a operational regulation. I'd be happy to answer any technical questions the committee may have prior to going to the public participation section. Thank you.
Committee? Looks like everybody's good to go. Councillor Ridley.
Thank you, Mr. Chair. I just had one question in regards to submitting the records to the police, because it sounds like you said there'd be a couple different methods, perhaps spreadsheets and software. Do they have staff, are they prepared to review those sheets on a daily basis, or will that just be for the records to cross-reference against a report that they've received?
And the staff sergeant looks like he's ready to answer.
Thank you, Mr. Chair. We do receive the written documents now and manually enter them into a database, which is obviously quite labor intensive and not particularly effective in terms of being able to search the information. So it is, the reports do get reviewed on a daily basis, but as a rule, when we have a specific item that we know has been reported stolen, perhaps in a break-in or from a robbery or something like that, then we would go back and specifically search for an item that we want to connect up with the case.
Any other questions, technical questions? Councillor Helmer?
My question is around the verification of ID. It sounds like a good idea. But there are people in the community who have ID problems, you know, like they don't have ID, they can't access a number of services because they don't have ID, and there are in fact, you know, services out there to try and help people get their ID when they don't have it. Some of those people are in pretty desperate straits. They may come into possession of goods through legitimate means that they want to sell, and I'm concerned that they're being blocked from that market because they don't have ID, and we're kind of compounding their ID problem. I wonder what our staff think about that and to what extent that's a concern.
Through the chair, that issue has never been brought up. The focus is on items that may be allegedly involved in a break-and-enter or robbery. And I know there have been situations where immediately after a break-and-enter happens, the product is at a secondhand store and there was no verification of ID. So I would think it would not be a huge hardship for the licensees to verify ID via a photo. I would think that somebody that has been involved in a robbery or break and enter, be as a primary or an accessory, in wanting to move that product through a secondhand store or pawn shop, they likely will abstain for providing identification. So we feel that's just another regulation that would add in preventing secondhand stores, but for being the locations where alleged products that are stolen through robberies or break and enters are disposed of.
Okay, so along the lines of unintended consequences, so somebody has stolen a bunch of property and they're trying to unload it on a secondhand store, and the barrier right now of showing ID is not there, and so they feel comfortable doing that because they think they can get away with it. Now we're gonna say you have to show ID, that now is deterring them. What do they do with those stolen goods? Because they're still gonna wanna sell them. And now the secondhand market where we get reporting of serial numbers and things like that is gone. And so it seems to me like the chance of recovering the goods has just gone down rather than gone up. It might be deterring the sale and maybe the stealing in the long run, but it's not necessarily helping people get their stuff back. So I wonder if we've looked at that and look at what the impact might be, because it could just go to a kind of even grayer market of, well, I'm not gonna go to a pawn shop, I'm gonna go to some guy in the street who, you know, is even maybe more dangerous and even more problematic than dealing with a secondhand store.
We'll give that some consideration in our discussions. This is just a draft bylaw at this point, but a very good point. The other thing is that the internet is very popular, obviously, for disposing of a variety of products, and nobody is checking identification on the internet.
Councillor Van Hulst?
Thank you very much. Question about the 5-day waiting period. So someone would bring an item in and they wouldn't get paid for 5 days either? Is that I'm just wondering how that works.
Through the chair, that would be a business decision that would be made by specific secondhand stores, but the intent and the best practice in other municipalities is, for example, somebody brings in a bicycle, the serial number off the bicycle is recorded, provided to the police. That bicycle then is held in storage for 5 business days as opposed to being displayed for sale. Because we've heard in cases in London where bicycles are stolen, taken to secondhand stores. The person whose bicycle was stolen sees that bicycle in the street. The person riding that bicycle simply went to a secondhand store and picked up that bicycle that same day. So that is something that we feel would be a reasonable, not a hardship regulation to introduce into this type of business.
Okay, thank you. And I do hope we'll do our best not to have these be a hardship, right? It's really easy for governments to say, oh, this will solve a problem, and we really just download lots of work onto other businesses. And
So I think there's a point of order coming in from Councillor Usher.
Wait a minute. I thought we were just here for question. We're not finished with the PPM yet.
Correct. So we're just asking technical questions.
Okay, thank you. Do we have, is there something we can do about copper being stolen from air conditioners? That's a very, I think, frustrating thing that happens. It's taken to the scrap yards, as you were talking about. You mentioned copper, but that one's very frustrating because for a very small amount of money in copper, a very expensive piece of equipment can be rendered useless.
Through the chair, I don't think that the business licensing bylaw can specifically address the process of theft of copper from an air conditioner, but I believe the regulations that we're proposing with respect to checking identification, keeping a record of transactions, if somebody, an individual keeps going back to a specific salvage yard with rolls of copper, on a daily basis, I'm sure the police would like to have that information via the records. I don't know if Sergeant Harvey wanted to add anything to this discussion.
The theft of precious metals is an ongoing challenge, obviously, from a law enforcement perspective. But certainly any provision that will perhaps deter people from trying to sell the copper or whatever metal in a salvage yard is good. The interesting thing with the precious metal issue is that obviously, unlike a stolen television, a bundle of copper is more difficult to unload for money, and there's only specific places that you would be able to take it. So that does make it a little bit easier, but obviously any improvements in terms of the recording of the information and such is going to be beneficial to help deter that.
Okay, and seeing no more technical questions, we'll go to the members of the public. And so we'll open up the PPM. You can just state your name and we'll get you started. And whoever wants to line up on a microphone can do that, and you have 5 minutes.
Hi there. I have something prepared I'd like to say, and if after that, I wouldn't mind bringing that slide back up, so maybe I can touch on some of those issues as well.
Which slide, so we can get that in the
The
email?
slide of the proposed changes to the secondhand license. So my name is Jesse Belak. I'm a third-generation pawnbroker. I'm representing Beback Jewelry and Loan. We have 3 locations in the city, and we've been in business since 1995. So I have a few issues with originally what was proposed. I see that it's changed a bit, so I'll touch on that and then touch over there. My first issue is definitely with a picture-based system, a cloud-based picture-based system. I feel like some city councilors don't understand what the current procedures. As of right now, no secondhand store has to provide information to the police at the end of the day. As a pawnbroker, I do. I have both licenses. But as a secondhand store, I do not. So I think there's steps that can be taken before we decide, hey, let's take all these pictures, send them in. It sounds good, but I think it is a very, very big burden that might not be capable for a lot of stores. Some of the steps, for instance, is, I think we touched on up there, is maybe the records actually being sent every day. I got no problem with that. The software that we use, every transaction is inputted every day. You want the purchase records as well? I'll send a separate record. You just tell me where to send it to. It doesn't bother me. I have nothing to hide. So that would be step 1 I think we should take. Second is maybe an infractions based. It's good to hear that there was only 1 infraction, but maybe multiple infractions from locations. There could be some kind of punishment or fine. And third is increased monitoring, which brings me to my second concern is I don't believe that the City of London or the City of London Police Department has the resources to monitor all this. I say this from experience. Anytime we have had to deal with a London police officer, they are very limitedly trained or not trained at all. They don't know the proper procedures, and usually we are the ones bringing forth to them how to deal with the situation. My third concern is the fairness. If you're going to install this, it can't just be on certain items. It's got to be everybody in the business license follows the same rules. That's why we're in that business license. We're a secondhand license. It's not somebody pays $500 for something or somebody pays $50 for something. There's a different set of rules. There would be absolutely no fairness to that, and you're punishing the people who want to do things correct. I've only noticed one other secondhand license person here, and it's probably not a coincidence that it's us because we're probably the only ones that will follow any new rules that you put in place. I can't say that for sure, but we've had 5,000 items at one location from January 1st to June 30th, and 2 have gone back to the London Police Department. So that's less than 0.5% of the items. For me to take a picture of even half of those items, it's unmanageable, and that's one location. I can't do it. I can't tie somebody up all day, every day, taking pictures and uploading them. Another concern is if you leave that gray area, people will find a way around it. It's not a black and white issue where you say, these items, there's always going to be a way around it if it's not black and white, and that's why everybody has to follow the same rules. It can't be some do others. In In regards to the items up there, serial numbers, we already do that. We don't deal with anybody under 18. We definitely do not want anybody in our stores under any influence. I got no problem with a police check. Verified ID, we do not do any business with anybody unless they have identification. That's a policy that we've put in as a store. So if they don't have ID, sorry, you can't do business with us. So I got no issue with that one either. Recording all transactions, like I said, the software keeps those transactions as long as the hard drive's big enough to hold them. The submissions to the records to the police, I have no problem with it. But if we're going to increase what we're submitting, like I said, there has to be somebody there that's going to monitor it. We can't be sending these and then you're talking one item here, one item there. It's a waste of time to the business owners. The focus on break and entering items, I'm sure, you know, what's really a high-end item or an item that's always stolen. It's whatever somebody can get their hands on. So it's kind of objective. Like I said, submissions of photos, I definitely do not think it's an idea. I think you're putting way too much of a burden on reputable businesses. And the 5-day hold period, I have no problem with that either. Sure, if you would like us to hold any item we buy for 5 days, you know, we have big enough stores that we can do it and the items won't put out for sale for that. So mostly it's the photos. I feel like it's going to bog down our business so much and put an unfair, I don't know how you explain it. Something just unfair to us to have to deal with that, to take a picture of something. And it's also, you know, people's privacy as well. If it's an identifiable item, it's not fair to them either. So I appreciate your time, and everybody, I hope you take in consideration the concerns I have going forward.
Looking for any other speakers?
Hi, I've prepared comments as well. My name is Daniel. I'm president and owner of Coin Canada Limited. Coin Canada does cash handling and coin processing for London Transit, Impark, Salvation Army, and various parking, laundry, and vending companies throughout southwestern Ontario. We've been in business since 1986. The next time you're at the grocery store, take a look in the roll of coin and the till. It probably came from us. The reason I'm here today is because we own a business unit called London Gold Buyer. Since becoming aware of the discussion of revamping the second-hand purchaser bylaws, I thought it'd be prudent to add some perspective from our experience, how various scenarios would impact our business, and hope to work with you to reach our mutual goal of having less items stolen in the first place. I should explain how I got in this business. It was not to buy stolen goods. The demographic of my client is a 55-plus-year-old female. She may be considering downsizing from a 5-bedroom home in Old North to a 2-bedroom condo downtown. She may have inherited an estate from her parents and have no idea what the value is. We have built a secure, private, and professional environment in which she can get a fair and transparent offer for her goods. As a matter of fact, we just spent almost $1 million building a new facility at 475 Highbury. The investment is not aimed at helping criminals with handfuls of stolen jewelry. Since day one, we've implemented a Know Your Customer rule. We do not buy any item from anyone under 18 or without proper government-issued ID. We take down name, address, and phone number of each client and have them sign it. We have video footage of every transaction that's kept for approximately 1 month. We have hard copies of every transaction we have done with any client in the last 7 years. Because of this, we have very little, if any, questionable items turn up in our possession. Quite frankly, the criminal would be stupid to try and deal with us in the first place, as well as Jesse's facility. As a London resident myself, the last thing that I want to do is facilitate crime in my community. As an example, what does not work is our experience in Hamilton. We have a kiosk in Hamilton which works under much different bylaws than we have prevalent in London. We purchase between $50,000 and $100,000 of material each month at this kiosk, and we are forced to hold these items for 30 days. We also provide a description of each purchase on a cloud-based drive daily. For us, that means $100,000 of capital in non-productive use and reporting that takes up much employee time. Since we've opened in 2013 at that location, we have not had one instance where the police have contacted us to take a look at these items. That being said, I think it would be reasonable for a digital picture of each lot purchased to be made available electronically, as long as it does not contain any personal identifying information of the seller. A short hold period, such as the 5 days you're discussing, would allow the police to conduct a search on any secondhand dealer and provide further information if it is required. Again, the privacy of the clientele should be paramount. If there is more information needed, then we'd be more than happy to provide it. I would propose that the items purchased be photographed together in a lot that they were purchased in, as opposed to one each individual item. It doesn't make a whole lot of sense for us to take a picture of single earrings or broken necklaces that were all, if they're 20 or 30 coming from somebody's jewelry box over time. But if it was a group that was from a stolen item, then it would make sense that it is a grouping as opposed to one individual ring. I would say that anybody who is a license holder in a secondhand goods business should take a picture of it regardless of the item. Just because it's a power tool, a DeWalt 18 volt, if it says Bob written on the side in marker, that's an identifying mark. Just because it's a bicycle, which was used as an example, somebody dealt with bicycles. If you have I don't have the serial number of my bicycle, but I know what it looks like, I know the paint color, I know what modifications would be on it. That picture would be very useful. If you are going to use a picture base, do it on a dollar value, minimum $50, $100, whatever the number is, as opposed to just these categories. If you're going to use it complete, or don't use it at all. No legitimate secondhand dealer will have issues with a reasonable attempt to stop criminals from coming into their stores. We do not need them or want them in the first place. And those who should not be allowed to do business in this city. Thank you.
Thank you very much. I'm just looking for any other members of the public. Going once, going twice, and thank you. We'll look for a motion to close the public participation meeting.
Closing the vote, the motion carries 5-0.
So we'll go to committee if there's any questions for Squire.
I'd like staff to.
Oh, sorry. Sorry, Squire first, and then I'll come back to you.
Yeah, first question is the one I ask all the time, and I'll ask it to Mr. Katolik. Are you prepared? It seems like these gentlemen who have spoken through you, Mr. Chair, have some interesting ideas and some good knowledge. Are you prepared to meet with them and before we get the bylaw in its final form and see if there can be any changes?
Through the chair, I've already met with Jesse. I've not met with that individual, but I'd be happy to.
Great. Now, my second question is, it occurred to me that I have a daughter who's always shopping in secondhand stores and coming back home with things, usually to revealing things, but that's another story. I just wonder, a lot of these are operated by charities and they get lots of clothes from stores and things like that. I just wonder, is there an exemption for them? Because it seems to me it would be really onerous for their secondhand shops. They have high volumes of items. A lot of them are expensive clothing. Is there an exemption for them, or if they're operating as under the auspices of a charity? Because I didn't see that in here. They're still in the business of selling secondhand goods. So I'm worried about the onerous nature of what we're requiring from these businesses.
Through the chair, there is no exemption. The proposed fee is $311, and that takes into consideration administration and enforcement costs. But as this committee and council has asked us previously to recognize registered charities and provide lower or no fees in terms of the business that they're in, we certainly will take that under advisement.
Squire again?
I guess just my concern is it's not so much the cost of the registration, but if we're creating a really high responsibility or onus on a business that's just making money for charity, that they're photographing all these items and having to do this work. I do have a concern about that. I'm not faulting anyone, it's just a concern. Councillor
Cassidy, sorry, I forgot your name for a second.
Thank you, Mr. Chair. So just sort of jumping off from Councillor Squire's point. So is there any distinction between a second-hand dealer and a consignment store? Because I believe that's what he might be talking about, where they sell clothes and shoes, some jewelry, but not, you almost always costume jewelry, nothing precious.
Through the chair, there currently is no differentiation. Whether you're selling used CDs or used clothes, what we're finding is there's a lot more of these secondhand stores because a lot more people would like to get rid of product out of their house rather than take it to the dump. So we see that with clothing bins throughout the city. So a lot of people will take things, personal items. The focus of all these regulations is on crime prevention. So we certainly, if somebody comes in with half a closet of clothes, that's fine. That's actually, we encourage that. So, you know, it goes back into the marketplace. There'll be no requirement to take photos of those clothes. And what I heard at the public participation meeting from this gentleman here about when people bring in like a lot of jewelry, that's something I think we're going to have to focus and revisit in the bylaw in terms of photographing.
Thank you for that. So, yeah, just by its very nature, I think a consignment store does a lot of these things already. I think they have a list of clientele that actually go through their closet on a regular basis and bring their things there to sell. So they have a complete file of everybody that they deal with. So it's not like somebody has broken into somebody's home and stolen all their designer clothes, although I suppose that could happen too.
Councillor Van Hulst.
Thank you very much. Just through the chair for my own clarification, so secondhand store, is that something like the Salvation Army thrift store?
Yes, those types of stores do get licenses currently.
However, I think everything they receive is a donation, so I don't know how that would be subject to crime. I'm not going to steal something and then give it to the Salvation Army, unless I'm Robin Hood. But so it seems to me that really some of these things there's only a concern if there's money being given. In the case of a consignment store, an item comes in and the proprietor is providing them with money. That seems to me where there's a concern. So there might be some regulations just aren't necessary for some types of stores. Maybe we need a distinction of those. Perhaps you would respond to that.
Through the chair, we'll have another look at the definition and look at best practices across Ontario and Canada that have that distinction.
Great. Any other? Oh.
And thank you. Maybe I can just continue on the point that I had made. That wasn't a technical question, but it was certainly brought up again by our guest here, and that's just doing things that are too onerous. And certainly, if we're going to make them take a bunch of pictures or provide a whole bunch of information that the police aren't really going to follow up on, it's something that's make work. I won't support. I think we need to do the things that make at least incremental differences without putting a lot of burden on downloading a lot of burden on the businesses, because it's I think a pet peeve for me. I see it happening all the time in other areas. My wife owns a business, and I shake my head now and again at what the province is asking, because we don't supply something. Now, if we can ask them to do something and then supply them the help, that's a different story. But that's my comment.
Councillor Ridley.
Thank you. I just wanted clarity on the attachment on page 109. There's a letter attached to this item, and I'm not sure if it's relevant under the lodging houses or if it's actually should be attached to a future agenda item. So I wonder if we can get some clarity about that. This is the letter from Candace Keeling, and I believe it specifically references Airbnb. So is this what we're dealing with today have anything to do with Airbnb? Or was this letter misattached?
I don't believe so, but I'll look to staff if they want to wait.
I think it was misattached for a future meeting down the road.
Thank you. I assume that was the case, but before we got off of this, I thought it warranted touching on that anyway. I think that there's been a good discussion. I think there needs to be some more consultation with the industry, and I'm glad that Mr. Katolik is willing to do that. I think there's probably a larger market than what you're aware of in secondhand shops in terms of the clothing industry and other industries as well. I know for myself, I don't think I've bought anything brand new in about 5 years, just as a matter of environmentalism and buying used clothes that way. So I think, I don't know if all those businesses are licensed. I know they all should be, but I don't know if enough education and work has gone into that and if they have been consulted on the potential changes to the bylaw. I know you're saying it won't be onerous in those situations, but perhaps they have some valuable input as well, seeing that we're seeing an expanding market in that area. So I just wanted to flag that and say this is a file that I'll watch the next bylaw come back on, and thank you for all the work so far, and thank you for everyone who came and spoke about it. And I think one of the comments I heard, and I was aware of this, but I was glad it was brought up, is, you know, the people who are using the secondhand market aren't always perhaps what people typically think are. And I like the comment about privacy. If my grandma gives me some really expensive earrings, but I don't like them, I don't want that to be advertised that I sold them through the secondhand market. So I think keeping those factors in mind and protecting the public and trying to balance that is important, so.
So I believe Councillor Usher, you were on the list, but is there any other speakers? Councillor Helmer, and then.
Just one other question, that perhaps it's for the staff sergeant, but what is the volume incoming of the reporting you're getting now of items that are, you know, on a daily basis? Is it in the hundreds, thousands? You know, I just heard the one comment where he's like, yeah, we've done 5,000 items in basically 6 months, and that's just one, and there's 80-something stores. They could be huge amounts of volume. I just did a quick calculation. It could be like 500,000 items, which is a lot. So I just wonder what's happening now.
There are a large number of items that are reported on a daily basis. It really depends on the ebb and flow of the businesses themselves. And the reporting requirements are different between the items that are pawned versus the items that are sold or recovered as secondhand. So some businesses only report pawns, others report all their transactions, although they're not required to, which is nice. But it is a considerable volume. It would be hundreds of items a week that get reported through to the police.
Okay, so seeing no further speakers, I just throw the chair to Usher because I wanted to ask some questions, if that's cool.
I've got the chair.
Great.
Councilor Sally.
That passion made me forget my question, so give me a sec. But I think my question was, since the London Police is here, just overall, just your experiences. I know some of the gentlemen that are here today who are presenting, I know they run great businesses and things like that, but just generally speaking of the industry and some of the challenges with you're trying to do some of the work with the faxes that come in, the one that came up with the slides seems to be hard to kind of interpret that information. How beneficial is this, and how much of an impact in resources? Because I know we always talk about policing and the demand and the resources and the lack of resources that you guys have to do what you need to do. I think this almost helps us and maybe will help our budget down the road. But anyway, I'll leave that separately. The chief's not here. So I'll just ask you that question first to the chair.
In terms of the value of the information, it's most valuable in regards to items that are difficult to identify. Items that, like such as jewelry, valuable jewelry that don't have a serial number. So the notion of obtaining a photograph of expensive jewelry items, an example such as that would be extremely beneficial. So when we see perhaps a break-in that's occurred where a large amount of expensive jewelry has been stolen, it would be fairly easy for us to go back and look at the previous records to determine whether those items have potentially been taken to a secondhand store or a pawn shop.
My second question, do you know from experience, and I know you can't give us necessarily hard data because of sensitivity to some of the information, can you kind of elaborate of just your experience with the industry, notwithstanding the fact that I know these groups that are up here today do a great job, and that's why obviously they're probably here, but can you kind of let us know what kind of enforcement history have you seen, as far as, because I believe when I was talking to Mr. Katolik in the past, I think there was 2 businesses that had not too long ago had to be closed because they were found in infractions, if I'm not mistaken. So to you and I guess Mr. Katolik, I guess.
I'll just comment that Certainly, the majority of the transactions don't involve any interaction with law enforcement, but I would say probably on a weekly basis, we recover stolen items from a pawn shop or from a secondhand store. It certainly would be a small number compared to the number of actual transactions they have. In terms of their compliance, I'll leave that to Mr. Katolik to comment on. Thank you.
In terms of our partnership, we work closely with the police on doing enforcement blitzes. We either do them individually or in partnership with the police. And what this bylaw will allow us to do is do some secret shopping. So we could take some electronics to these stores, want to dispose of them, and ensure that our identification is checked. What we currently do is basically go into these stores that are licensed. We find the ones that are not licensed. We educate them to get licensed. But our focus is on looking at their record keeping to make sure that the products that are coming in, specifically sporting goods, bicycles, electronics, that they're properly being, the records are properly being kept.
So thank you, and through the presiding chair. So I guess just my last comment is you know, happy to move this, and I see there's already a seconder. I think just for the members of the public, just speaking as a member of the committee, so what will happen is after we vote here today, this will go to our super big omnibus, which is going to be Squire's favorite day. So make sure to come down in September, where we'll vote on all of these bylaws in one shot. So it'll be great. Bring your sleeping bags, and that's it for me.
Councillor Van Holst.
Thank you very much, and through the presiding chair to the officer, wondering if you can give us an idea about the difference between a clothing consignment store and a pawn shop in terms of how often you might find a stolen item there.
I think a lot of it comes down to the type of items that are stolen in break-ins and robberies and such. And certainly, generally those items are valuable but small and easily transportable. And therefore, the items that I would consider traditionally ending up in a consignment store, such as clothing or perhaps household items, are not what are generally targeted in break-ins. Break-ins target electronics, easily transportable items. The majority of offenders are not in a vehicle, they're on foot. So jewelry, small electronic items and things like that, which do have a significant value despite their small size, and are therefore more easily sold as secondhand goods in a store or on the internet, as Mr. Katolik has suggested.
Councillor Ridley.
Thank you, Mr. Acting Chair. I can't see the motion on the screen, but I did want to ensure that the letter that was sent in by a member of the public will also be referred to the appropriate meeting. Okay, sorry, I can't see it. When I flip my screen, I still see the video, so.
Certainly. Okay, anyone else? We'll vote. It's moved and seconded. Let's vote.
Closing the vote, the motion carries 5-0.
Pass control back to you, Mr. Chair.
Thanks, quarterback. So I just wanted to thank the members of the public for coming in and participating in this. Has been very helpful, and Ms. Katolik has made a commitment to reach out and hear from you all. So really appreciate that. I think you guys have given us some great information, and it's very helpful, and you're always welcome to reach out to us directly as well as individual counselors. So now we are going to, Councillor Ridley has an item she'd like to raise in committee. So, and we look like we already have a mover, and we'll, I guess, go to Councillor Ridley first, or do you want to? Unless Squire wants to talk first. Councillor Ridley.
Thank you, Chair. It looks like I already have a mover. I'll look for a seconder. So I'm basically asking that we revisit the home occupation business bylaw. It came to my attention that if people are pet sitting, they're not allowed to do that under the current bylaw. We have other methods to control, including limiting the number of pets that are allowed at a municipal address, noise complaint, and other ways that we could manage this. If someone wants to pet sit for my dog when I'm on vacation, that would be really great. I can't pay you until we get this changed, though. I think that it should be allowed. So I hope that the committee will support making this change and know that there are other ways that we can deal with issues as they arise.
Thank you. Did you have a letter submitted from your dog as comments? No?
I can get one to you before council if you would like.
Thank you, that'd be very helpful. Any speakers? Councillor Usher?
Quickly, so this is really asking, is it Mr. Katolik to have a look at this and provide a necessary amendment to provide for individuals to operate a pet boarding and or pet sitting business from their home?
Correct.
So, I just want to hear what Mr. Katolik has, or add that, and or I will ask a question.
Mr. Katolik?
Thank you. Through the chair, this really comes out from the world of apps. There's some apps out there that if you want a vehicle, you hit an app. Well, now you can hit an app and find somebody that'll pet sit for you. So Rover is the name of the common one used. And there's a lot of folks in London that are on Rover and will offer this service. So it's just kind of like Airbnb. We're just getting into reviewing this. We were asked by council to review Airbnb, so now we're looking at this. Our focus is going to be on nuisance, so we definitely would want to have a limit on the number of dogs there to be in sat at one time. A reasonable limit would be 3, because that is how many dogs you can have on your property currently. And the other proviso we would look at is that the dogs be licensed. So we want to ensure that it's safe for the neighborhood. There's a minimum nuisance. If there are nuisances, then we would definitely invoke the noise bylaw in response to any complaints. In terms of timing, we could likely come back to quarter 1 or 2 of next year with a report back.
Thank you, Mr. Chair. Thank you, Mr. Katolik. And the reason I asked for this is that I admire the motion, but I want you to know that I had a neighbor once, and they were doing this without our knowledge, and this was just beside me in the city. And every day, that person used to walk 4 little puppies. And then they would walk these puppies. About an hour after, or less than an hour, I see them walking 4 different puppies. And then after that, 4 more puppies. And one day I look in the backyard and I saw a whole lot of puppies. And then somebody told me that they were out at the corner of a certain street selling puppies. So they were not doing what this is saying. They were raising puppies, and I didn't even know that. So I'm glad that there will be a limit, because that's the important thing to me with respect to the nuisance aspect of it. And I think that it needs to be controlled, because if they have to go to walk, they can only walk a certain number of these pets at a time. So I'm glad to see that you're going to encompass all that in this. And you seem to have it in your head well, probably more than Councilor Wrigley. I'm just kidding you.
Were they Dalmatians?
Thank you very much.
Any other speakers? Seeing none, we'll call the question. Thank you, Councilor Ridley, for visiting.
Closing the vote, the motion carries 5-0.
So committee, I see we have items remaining, number 13, 16, 17, 18. Do you want to just deal with them all in one? I'm seeing a nod from Squire, so we'll get those all up for you for a motion.
Four of them are to do with advisory committees, right?
Correct. It's up to you if you want to pull 13.
I'd like to deal with 13 separately. Mr.
Okay, so we'll do 16 to 18. (15 to 18). So you guys, our committee, are you guys okay with adding number 19 as well? Or did you have something? You okay, Square? Deferred items. Okay, so we'll add that to, nope, Councillor Cassidy, did you have your hand up?
I just want to make a comment on one of the items on the deferred matters list.
Sure, go ahead, inspire us.
Because it's in Ward 5, and it's the Cat Adoption Center, and I just want to comment about the name Catty Shack. I like that.
And we're calling the question unless there's, no? All right, call the question. And we're voting. And we're voting.
Closing the vote, the motion carries 5-0.
And we'll get item number 13 up, and Councillor Usher, go ahead.
Mr. Chair, I'm just looking for some advice on this, perhaps from staff. We dealt with this matter before. And did we come to a conclusion or we referred back to staff? This one with the condominium corporation at Berkshire Court. Okay.
So it's, from what I'm hearing from the clerks, the person wants to come requesting just to speak on the item. That's all we have.
But whether I say yay or nay will depend on where we are with this, because I believe that we dealt with it before. Can you bring me up to date?
I'll look to Mr. Katolik.
We dealt with this item, I believe, 2 cycles ago. It was regarding a buffer strip of naturalization area between 2 condominium complexes. The only outstanding matter is that this citizen does not believe that a specific thistle should be, he believes it should be removed, and we are working with Ministry of Environment to determine whether that thistle is noxious in a urban environment. I would respectfully suggest that this be referred to staff for a on-site meeting with our enforcement officers. So this isn't really a committee matter.
And Mr. Chair, that's the reason I brought it up, because I don't think that we should be dealing with it via this process. Staff should work on it first. And then if they want to come back, then that's a different matter. So I would be more inclined to go with Mr. Katolik's motion, refer it to staff.
Okay, so we'll get your motion up and we'll look for a seconder. So to refer the matter. Any other speakers on this item, on the referral? Speak now or forever hold your peace. Okay. Too late now.
Closing the vote, the motion carries 4-1.
Great. So now we have, I know we have 2 in-camera items that we're going to go into camera for, so we'll get that up on the screen. To go in camera. Sorry. Oh, sorry. So, sorry, Councillor Cassidy, did you want to say something? No. Okay, so from the last conversation, Councillor Usher was requesting legal advice on. Sorry, Councillor Armstrong, sorry, Councillor Armstrong was asking to go in camera for number 5 as he had some questions that were that would have some legal implications. So I think his clerks were asking for some wording on the reason to go in camera. So we'll get that up in the screen. And then also the other item was my request in regards to our bylaw related to an appeal from OMB. So that was the 2 items. Well, that's going to be for both. Yeah. So 1 second. so I'm gonna have to read the motion. So approve closed session for following reasons: a matter pertaining to personal matters about identifiable individuals, including municipal or local board employees, with respect to the awarding the 2017 Queen Elizabeth Scholarship; a matter pertaining to advice subject to solicitor-client privilege, including communications for that purpose as it relates to an enforcement matter; a matter pertaining to advice with subject to solicitor-client privilege, including communications necessary for that purpose and for the purpose of providing instructions and directions to officers, employees of the corporation with respect to adult entertainment parlor and body rub parlor licensing. So that's up. Moved and seconded. Any debate? And we're voting.
Closing the vote, the motion carries 5-0.
So we'll make our way to committee room 3, and for the members of the public, you can hang out here if you like. And what we'll do is, once we finish from being in camera, we'll come back out here and report out accordingly. And hopefully we won't be too long, but
that a quorum, right?
Yeah, it is. So, Squire, if you wanna get going, we can start if you'd like, since we'll have quorum with you, and we'll get you out of here.
There they are.
All right, so, we'll just have to report out from in camera. So I'll ask Councillor Armstrong to report out from in camera. Councillor Cassidy, if you're ready, go ahead.
I'd like to report progress for the items that we went in camera for.
Sorry, I saw you getting set up. Sorry, Councillor Usher, I'll get you next time. Perfect. So now we're going to deal with an item that was deferred. It was the last item now we're dealing with, which was number 5. At the time, Councillor Armstrong had the floor, so if he wants to take the floor at this time, he's more than welcome to.
Well, on number 5, I guess the thing is that we need a motion to defer the matter to, I guess, council. Staff to report back. Can we do that? Like, I'm not.
So this is a public report, so it's a consent item. So unless you want to do different direction from.
Well, yeah, I guess we can I can move receipt of it for now.
All right, sounds great. So we'll get that motion up.
Yeah.
Floor is still yours, or are you good? Any further speakers? So we'll look for a mover and a seconder. It's been moved. It's been seconded. Any discussion? Call the question.
Closing the vote, the motion carries 5-0.
So since we've dispensed of all our items, look for a motion to adjourn. Moved by Councillor Squire, seconded by Councillor, sorry, I see some hands, but this is Councillor Usher. All those in favor? It's you. Nope, hold on, Councillor Armstrong.
Just on the last item, am I reading this? I'm sorry, somebody just raised this. Is this got in here that we're going to require a public participation meeting?
That's right, that's what it says. So we received the report.
Because,
Take that out now.
yeah, we don't require it, and that's what we discussed before we went in camera. As you recall.
So we'll have, we'll put, if you like, we could do a motion
Sorry, I
for
have to-
reconsideration.
I'll move reconsideration.
So reconsideration
just to
moved and
remove
seconded, so we'll get that up on the screen.
that. Sorry.
And then we'll get the motion that will reflect if the reconsideration passes. So the motion is up. Moved and seconded. On the debate, we'll call the question.
Motion carried 5-0.
So just to be 100% correct, so Councillor Armstrong, you wanted it to say exactly what on that one line? Did you just want that?
The public participation meeting is not required. Take that out. That's what, we're clear on that.
So we'll get that up on the screen. Then look for a mover and seconder on the screen. While we're doing that, is there any speakers? Seeing none, we will call the question once it's up. So make sure you read it.
No, because.
Go ahead, Councillor Usher.
My only concern about this statement is that it does imply that we'll have a public participation meeting. I think it would be better if you have the whole thing and just remove the idea of the public participation meeting.
Yeah.
Because this is saying that the report be received.
So what the councillor is saying, he wants what was up before, but just remove the piece that said
But
the reference to
that's
public
part of the
participation meeting.
staff report.
That it's not required.
That's it. It being noted that the public, Well, but it's part of the staff report.
Well, I can't take it out of the staff report. It's always going to be part of the staff report. That's what's presented to you.
Not if you say it being noted that the public participation meeting will not be required.
So again, Counselor, so we'll just add that. So we're just cleaning the language up, and
Try to be difficult. Try to be right.
so Counselor Usher Armstrong, if you would like to read it in the committee, make sure that this is exactly hits the wording that you like. Third time's a charm. You want to grab the microphone, make sure you're good?
I'm good with that.
All right, so we'll look, it's been moved by Usher, seconded by Armstrong. I'm not seeing any further discussion, so I'll call the question.
Closing the vote, the motion carries 5-0.
For a motion to adjourn, moved by Councillor Cassidy, seconded by Councillor Usher. All those in favor? Opposed, if any? And it carries. Good night. See you in a week.
Okay.